Consumer Affairs, sorry for the delay. We had a Rules Committee that went a little long. Well, first of all, it got delayed start till 12:40 and then it went long. So we've got 3 bills before us this afternoon. We've had meetings and hearings on all 3 of these already. We've had public testimony on House Bill 1150 already, and the others. And so we're in a posture today to just act on these bills. We won't be taking any public testimony. And as is our tradition, before we get started, I need to call on somebody to open us with a word of prayer, and I'm going to see if Chairman Burns would mind doing that for us, please.
Happy to, Mr. Chairman. Thank you. If you'll join me in prayer, please. Father, grateful for opportunities, and we're grateful for challenges. We're grateful for people who are willing to work together to find the best place for the people of Georgia. Help us as we make decisions today, and grant us your wisdom and your patience. In Christ's name I pray. Amen.
Thank you. All right, Chairman Harper, do you have a comment or question? Your light's blinking. Okay. All right, House Bill 1149, Representative Gullett. I want to thank Representative Gullett and Chairman Harper for working hard on this over the weekend and hopefully getting it in a place where we can take action on it. So go ahead, sir.
Thank you.
We've got a Senate committee sub.
We do. That's right. It's LC 510196S. And I want to appreciate the chairman and Chairman Harper for your help on this. So what we did was we narrowed it down to only work with swine who are not considered for food production, so potbelly pig, and that they're donated after 3 days. So they try to find the owner for 3 days. They're donated. At that point, they can be given away with the intent that potentially, if I'm an owner and I want to go get that pig back after, say, within that 10-day period, you can go to that rescue group that it was given to and pay whatever that rescue group or the individual the cost to feed it during that time period, and you can get your animal back. And we also kept, if you look at lines 83, if there are other animals outside of pigs, if they are gone to auction and they don't sell, that they can also give those away in 82 and 83. So the purpose is they go try to find the owner. If for whatever reason they don't get sold, they can either be then given away, euthanized, or and that's really it at that time. Happy to answer any questions for you, though.
Thank you. Do we have any questions? Seeing no questions, what's the will of the committee? Got a motion to pass. Senator Jackson, a second. Senator Hatchett. Any discussion? All those in favor of the motion, raise your hand. Any opposed? None opposed. It passed unanimously, and
Thank you. Thank you for your work on this.
It'll be on the rules calendar after its second read in the Senate tomorrow, I think.
Thank y'all.
Well, who's going to be the Senate sponsor?
Randy Robertson said he would carry it,
Okay, thank you.
unless there's someone he didn't carry one with the other, but he was willing to carry it. So, thank you.
Thank you. All right, next up, Representative Perkle, House Bill 1175. Again, we've got a Senate substitute on this one.
Thank you, Mr. Chairman.
Thank you, Representative Perkle, and appreciate you working with our committee members on this to get it in a posture that we can take action on.
Okay, 1175 LC 510179S is, I think, the one that we're working on. So there were 3 changes from when we last met. The first is on line 71. We added nothing in this article shall prohibit the storage and personal consumption of raw milk by the owner of an animal or resident of the premises of production. That's the changes that was made there. There was another change regarding the label. It will include the word warning at the front with a colon. Line number 1 is in that 138 to 140 range. And then the date, effective date, which will be the very last page. The last portion will be July of next year.
All right, I think those are all the changes that were discussed last time we met. Again, appreciate the work of the committee with the author on this. Any questions for the author? All right, seeing none, what's the will of the committee? Got a motion by Senator Anderson, do pass. Second by Senator Goodman. Any further discussion? All in favor, raise your hand. All right, it passed unanimously.
Thank you.
Good luck in rules.
Thank you.
Who's
Thank
the
you.
Senate author? Sponsor, whatever.
It's Senator Mullis wants to carry this particular bill. So.
All right, last on our agenda today, House Bill 1150, Representative Robert Dickey, and this is the Freedom to Farm Act that we've worked very hard on, both the House Ag Committee and the Senate Ag Committee. We've had two prior hearings on this, and we're going to take action today. I appreciate very much the chairman working with me on this. And Chairman, we do have a Senate committee substitute for this bill. Just bear with me just a second. So it's LC, be sure this 510194S. Is that correct? All right. We've had a few iterations of this. I want to be sure we're working off the correct one. And Chairman, if you'd like, I'll just go through the changes and then I'll let you comment, and you can answer any questions that may arise.
That'd be fine. Yes, sir.
All right, so we've looked at the House version pretty thoroughly, so I'm just going to hit the changes, if that's okay, with the committee. And I'll call your attention to line 80 and 81, the definition, or 79 through 81, minor change on the definition for CAFO, concentrated animal feeding operation. Means the same as that term is used pursuant to sections B and C of 40 of the Federal Code. And you all have been provided with a copy of that code in the past, and I think it's in your folder again today. Then on line 101 through 104, we added number C, no nuisance action shall be filed against any agricultural facility, agricultural operation, any agricultural operation at an agricultural facility, agricultural support facility, or any operation at an agricultural support facility, unless the plaintiff legally possesses the real property affected by the conditions alleged to be a nuisance. And what we're trying to get at there is that you have to be the legal possessor of property to bring a nuisance action, so that we don't have other entities, nonprofits, et cetera, bringing a nuisance action. Then this is, I guess, the most substantive change on line 109. We changed the time period that the facility has to be in operation to accrue the nuisance immunity from 1 year to 2 years. We've had a lot of discussion about this. 2 years statute of limitations is very common throughout our law. This bill, current law, protects existing farms if somebody moves to the nuisance. So, and it's 1 year in current law. If you move to the nuisance, buyer beware, you can't, and they've been in operation for at least a year, they're shielded from a nuisance liability. The way this is written is a significant difference in that the farm can be a new farm or a expansion of an existing farm. So the nuisance essentially could be moving to you. And with that significant change in the policy, it's my opinion, and I think it's shared by some on the committee, that 2 years is a fair balance to protect the private property rights of both existing landowners and the new entity coming in. Let's see, we'll go down to line, I have to refer back to the House version. So we struck out, there's language in there about swine CAFOs, and I felt like that was redundant, really. I mean, a CAFO, whether it's swine, chickens, turkeys, cows, a CAFO's a CAFO, so I didn't feel like that language was necessary. It doesn't change the impact of the bill, taking that out, and Legislative Council agrees with me on that. And then I think the only other change is so just to back up, if you establish a CAFO, that resets the 2-year clock. And I put in here that it only resets the clock for the portion of the farm that is the new CAFO, and preserves the existing nuisance protection that the other acreage had already earned or had. And then lastly, line 124 through 126, we added, some of these changes were things we had in House Bill 545 that we passed out of this committee 3 years ago, and this is some of the language we had in House Bill 545, and it just makes it clear that nothing in this code section shall preempt or override any Georgia Environmental Protection Division or U.S. EPA rules or regulations. So that's the changes from the House version. And now I will let the author speak to that, or if you have questions of the author.
Well, I'd just like to say thank you, Mr. Chairman, for working with this bill and for the communication. I think we've got a great bill here that had a good bill. We got a great bill now. Thank you for your work on this and real thoughtful work on this bill. All the changes you mentioned, I think you said them very accurately, and I'm in certainly full agreement in favor of those. The biggest one, of course, is moving it from 1 to 2 years, and I've given that a lot of thought. I've been thinking about that. I heard other members of your committee and even my committee had mentioned that, and that's where the change with CAFOs came in early on the development of this bill, and addressed those issues with that language in the bill, and now with the 2 years. I think that's the right number. I think any kind of work on a farm, if that would possibly be considered a nuisance, I think after 2 years that would be apparent and by any farm, and so I think that's a good compromise. It doubles the time from 1 to 2 years, so it's a pretty big jump, and I like that the 2 years, and certainly in agreement, and I certainly like the line 101 there about have to be a landowner or property owner to file a nuisance. So all good changes to this. Other were just clean up things, so to speak, about the CAFOs. And I think we got a great bill here that I appreciate you having me back here for the third time. It's maybe that's a lucky number today. I don't know. So appreciate the work your committee does, and you do too.
Thank you, sir. Questions for the author?
Mr. Chairman, I don't have a question. I just, at the right time, I'd like to make a motion.
Okay. So, I have a question, Senator Jackson.
Thank you, Mr. Chairman, and to both the chairmans, thank you for your hard work on this. I have a question around the section C that you talked about, and specifically on line 103, it says unless the plaintiff legally possesses the real property. So I just want to know, would this preclude, say, the spouse and the children who are in that home from being able to be plaintiffs as well? So, for instance, you know, if I'm driving a car and I get in a car accident, my kids are still, I don't have kids, but, you know, my fictional kids for this purpose are covered. But, you know, obviously children would not be the legal possessees of this real property. So would you be able to get damages for your family members who also reside in on that home?
Thank you, Senator, but I don't have an answer to that. I think you'd have to ask an attorney an answer to that question.
All right, Dave, would you like to respond to that, please, sir?
So, yeah, number 4. Mr. Chair, Senator Jackson, I don't think that's an issue here, mainly because the claim for a nuisance action is going to be based on the property value anyway. So you're not having individual harm in the sense of your kid got asthma and is going to have health, medical bills, et cetera. That'd be sort of a separate claim than what a nuisance claim is based on. So as long as the owner of the property, and also, sorry, to back up, I would also think that a very strong argument could be made that those people are legal possessors as well. So it doesn't say necessarily owner, but you know, a person who has some legal right to that land. But either way, as long as the owner or the person who is named on the lease, et cetera, is joining in that lawsuit, then that's going to maximize whatever damages would be available under a successful nuisance claim, regardless of whether children or a spouse was involved.
Thank you.
Senator Sims?
Thank you, Mr. Chairman. Mr. Chairman, and at the proper time, we will file a caucus minority report, but I would also like to state that I serve on the Ag Committee, and this is going to be brief. I'll be brief. Because I was a farmer, my husband and I, at one time. And it's important to me to protect the agriculture community. And I also want to say that agriculture is a huge, important economic engine in this great state of Georgia because of the regulations and the protections that are afforded all of the citizens and homeowners as well. And as long as we are prudent, we have prudent practices that continue to recognize the worth of our consumers, our business community that deals with ag, along with the farmers, who are very important to me because I've practiced this life before. So I understand the good, the bad, and the ugly of farming, okay? This productivity will continue. It's not going to go away. That's what I wanted to say, Mr. Chairman, and I thank you for allowing me to speak those words.
Certainly.
Thank you.
All right, Senator Harper.
Thank you, Mr. Chairman. First off, I think it's important that we address the issue in regards to our state's freedom to farm laws or right to farm laws, and I appreciate the work that's gone into this. I think there's a lot that can be said. I think we can to some points that have been made, I think, one of the things that we really got to look at going forward, we've lost a lot of production agricultural land in the last 20 years to development. And because of that, that means we've had a reduction in the ability of land that is utilized for agricultural production purposes. And many of you know in here that, we've got to double the amount of food produced to be able to continue to feed our nation and feed our world in the next 30 to 50 years. And so that's why it's important that we continue to protect our state's #1 industry. But it's not only important from that standpoint, it's important because it's a national security issue. Food security is national security, and I think what we see going on around the world and the situations that we've been seeing and the rise in input cost and the things that impact the everyday production side of agriculture have a substantial impact on the consumer. And if we're not protecting our state's most significant industry, and if we're not working to ensure that we're providing the food, the fiber, and the shelter here in our own borders, we're less safe as a country and we're less safe as a nation, and we've got to have policies that continue to allow us to protect that, and obviously making adjustments to our right to farm law in the right ways allow us to do that. That said, and I've had conversations offline with many of you. I do have heartburn about going from 1 year to 2 years, and we have discussed that. I think I think it's substantial to point out in court cases around the country where we have seen these laws challenged, right to farm laws challenged in court, whether it's in Minnesota, North Carolina, Texas, Oregon, Indiana, Missouri, among others. The courts have held up time and time again. And in fact, our right to farm laws currently and even under this new version would be very similar to those in other states around the country. But in those appellate cases, the court has claimed that they're all applicable and all constitutional. In the one case where there was a problem, and that case was brought up in this committee the other day, in that particular case, there was no recourse. There was, matter of fact, in that particular case, it was considered unconstitutional because there was no time window for a person to be able to file a suit. And that's the reason it was found unconstitutional. But in all the states where this is found constitutional, there has been a 1-year clock. And there also has been an ability for individuals to be able to file suit in those cases, which is why I think the 1 year has been in law for 30 years, and I think it's something that we should continue to support going forward, because I think it's met constitutional scrutiny throughout the country. It's met court scrutiny throughout the country, and I think it's something that we could continue to move forward. I think another thing that's interesting to point out, when I was reading the Missouri brief where their right to farm law was challenged in court, I thought it was interesting that the Missouri court held that agriculture is economic development. And because agriculture is economic development, it's good for the public purpose and it's good for public use, and it's in the best interest of the public that agriculture continues to sustain. And what the court found was that in that case where they filed a suit against an unconstitutional taking, the court found that that was not justifiable, but they went on to say that agriculture meets a legitimate public purpose, and because it does so, it meets the public use requirement, which in turn also rectified and continued to hold up their affirmation of the case in saying that the appellants did not overcome the presumption of constitutionality because of a private taking. And I think that's important to point out too, because courts have held different things in different ways around the country, and I found it interesting that that court held that in the way that they held agriculture in their state. That said, Mr. Chairman, like I said, I appreciate the work. I do, as I said, I think the 1 year is substantial. I think that's what's been established across the country. It's what's been held up in courts around the country. It's what's been in our law for over 30 years. I would like to see it stay 1 year. Obviously I'm subject to the will of the committee and the will of the body. But regardless of what we do, I think what we're doing moving forward is strengthening our law, is protecting our state's #1 industry, and at the end of the day, ensuring that we continue to protect our national security interests, because food security is national security. So with that, Mr. Chairman, that's all I got to say.
Thank you, Chairman Harper, and I appreciate your passion on defending agriculture and promoting agriculture very much. I do want to say that we have tried to be open. Certainly, we've had 3 meetings on this. The House had multiple meetings. Chairman Dickey's been gracious to come and 3 times, and I don't like to do my fellow chairman that way, but this is an important issue and important to him and to Georgians. We have worked with various interest groups: Georgia Farm Bureau, Georgia Agribusiness Council, Georgia Forestry, the Urban Ag Council. We've heard from the environmental groups, the Sierra Club, the Southern Environmental Legislative, what is it? The Southern Environmental Law Center. We've talked to some of the river keepers. The ag community represented by the trade groups that I mentioned are in support of this bill as it's currently written. I've not heard any pushback from them on that. I think we are moving agriculture forward and looking toward the future, and hopefully going to have hopefully we're going to see growth in agriculture and put some of those acres back into production. And certainly we are putting money in the budget to make our farmers as efficient as they can using technology and precision ag. And so I appreciate your support of ag, and I know you're a champion and a good champion at that. Senator Goodman, a brief comment or question, and then we're going to take a motion from Senator Anderson.
Thank you, Mr. Chairman. I just want to say thank you, Chairman Dickey, for bringing this. You know, the average age of a farmer now is, 58.5 years old? And if the family farm is going to continue, I've got 2 boys. If they go to school and come home, they want a farm. If we're going to support more families, we got to grow. And so this legislation like this, you could very easily say is going to help the family farm continue and hopefully grow. Sometimes I wonder if I want my kids to come home. With obviously I do, but when you look at the farmer's share of the food dollars, half of what it was in 1980. And for the members of the committee, we talk a lot about environmental issues and everything else, but the American farmers buying Tier 4 engines, and the farmers in Mexico and places like that, they're buying Tier 1 engines, and we're having to compete against that. And sadly, well, in terms of competition, in terms of the lack of competition, everybody that the farmer buys from and everybody that the farmer sells to is consolidated, every industry, and it's getting tougher. And so I just wanted to thank you for bringing this legislation. Hopefully it's going to give more protections for new farms so that boys like mine can come home, and hopefully the legacy of farming in Georgia and our family will continue. And I appreciate you working so hard on this.
Well, thank you, and I just, if I could just say one word, it's not just me, and Chairman Walker, I think, said it well. So this work on this bill was a culmination of a lot of different groups and a lot of different people, and I think it's a good balance. I think it's a good law going forward that not only farmers but also neighbors and consumers, everybody can be proud of and live a long time under this legislation. And it's some other things we could do, but I think this is a great start, great bill that we can be proud of passing. So thank y'all for your help and support and input.
Thank you, Chairman Dickey, and I also don't want to be remiss and not mention the Poultry Federation. They've played a key role in helping us with this too for several years. All right, Chairman Anderson, I will recognize you.
Mr. Chairman, as a farmer my whole life, it gives me great honor to make a motion today on House Bill 1150 for the farmers, for the future farmers, the people that put the shirt on your back, the people that put the food in your body, the shoes on your feet. This is a great bill for the great people of the great state of Georgia. I make a motion to pass.
All right, we have a motion to pass. Senator Summers was first on the draw with a second. Any further discussion? Hearing none, what is the will of the committee? All those in favor, raise your hand. Opposed, like sign. All right, the motion carries, and we'll see you in the Rules Committee, Mr. Chairman. LC 510194S, and who's your Senate sponsor?
I would defer to the chairman, Mr. Chairman.
I would like to carry it if you
I
don't
would like
mind.
for you to as well.
All right, thank you.
Yes, sir.
Thank you. All right, hold on a second. Senator Anderson wants to say something.
You know, it's not every day, but we have a very special guest in the room tonight, a former House Representative, the former chairman of the Mr. Tom McCall.
Oh, yeah, good. Hey, hey. Yeah, Chairman McCall started work on this several years ago, and so I'm glad to see it getting closer to the finish line. Good to have you, Chairman. Yes, sir. All right. We stand adjourned.